Okay, so good evening, Darmstadt. You're all here for a talk about trains. Yes, what a surprise. So we are going to be talking about trains, and more specifically trains in the context of freedom of information laws, how they can be used for good and silly. But before that, who are we? I'm Q. I do research at the Max Planck Institute for Informatics in Saarbrücken in my day job. I run Glauca Digital in my alleged free time, and I am, perchance, a noted train nerd. And we have...
Hi, I'm Anya, or Craftbyte, software developer by day, security researcher by night, and train nerd somewhere in between when there's time. Also, another fun fact, I know way too much about Slovenian law, so much so that many lawyers have at this point asked me about how freedom of information works.
So, we both have a bit of a shtick, and that shtick is getting up at chaos events and talking about trains. And at this point, saying that this is a shtick has perchance become itself a shtick. So, we have 103 slides to get to. Let's go on with it. Why do we even care what's in a ticket's barcode? What's the motivation for this talk at all? Curiosity? It's always good to be curious. You learn a lot about the world being curious. We can do some security research on them. Perchance there are some mistakes made in how your ticket is issued and then verified and billed for. Privacy implications, what data on you is stored in a ticket and how is it processed. And we can make cool things when we have access to open standards. For example, Zügli, which we'll talk about a bit later. So there are kind of like two types of train tickets here. We have this one that you from the Deutsche Bahn and this one from the train. I mean, both of these have some of my personal information on them, yeah, whatever. But yeah, these are two tickets I have bought. One of them is significantly more French-shaped than the other. So the Deutsche Bahn one is a UIC barcode. The UIC is the French association, the Union Internationale de Chemin de Fer. These have now been adopted as an EU-wide standard for all EU traffic.
Also by the European Railway Agency.
Yes, they've been adopted by the European Union Agency for Railways as a mandated EU standard for all tickets within the EU. This is an open standard. You can just go to GitHub and download the standards from the ERA's GitHub. It's free to use. There's no licensing costs. Friend-shaped. The other ticket is a UK Rail Settlement Plan ticket. These are a proprietary standard that's impossible to get a copy of. Trust me, we've tried, and this is the talk about us trying. Expensive licensing, even if you do want to use them. Decidedly an unfriend-shaped standard. We do not like standards like this. But we're hackers. When has a closed standard ever stopped us from getting access to what we want to? Come on, there must be another way. So we must start with a huge thanks to ITA and friends. Because ITA and friends made a wonderful blog post a couple of years ago on reversing UK rail tickets. This did not provide a full explanation of the work, but it provided a significant starting point into understanding where to go with UK rail tickets and how weird they are. So from ITA's work, we know that tickets use some custom base 26 encoding, i.e. the Latin alphabet from A to Z. They have an interesting, read bad use of cryptographic primitives. It would be nice to know more about that. The public keys are required to be able to read anything from these tickets because the tickets themselves are the RSA signature. You may be used to in a cryptographic protocol that what you get is your message and then a hash of it is signed. But in the case of UK rail tickets, the whole ticket is signed and the ticket is then the signature, so you need to undo the signature with the public key to get the ticket back in the first place.
This is the same as German VDVKA tickets.
Yes, German Verband Deutscher Verkehrsunternehmen Kernapplikation tickets do the same thing, also using RSA. This is a property that is only possible with the RSA crypto system. You can't, for example, do this with ECDSA. So the UK is forever stuck on RSA, which is beautiful. We have some of the public keys from ITA's work, but since that blog post, more public keys have been introduced, public keys have changed, more operators have joined and left the system, so we can't read all possible tickets. But reverse engineering doesn't give us the whole story. It would be nice to know exactly what's going on, what bits could we potentially never see from reverse engineering? What interesting policy goes on around these tickets? And we don't have all the public keys, so it would be nice to have those as well. There's a tool for that. What do they know? For German viewers in the audience, this is basically the British equivalent of Frag den Staat. It allows you to request information from the government under the auspices of the Freedom of Information Act. So what even is a Freedom of Information Act? In Scotland, codified as the Freedom of Information brackets Scotland close brackets Act 2002, and in the rest of the UK, just the Freedom of Information Act 2000. There are very few differences between the Scottish and the rest of the UK version. The reasons for there being a separate Scottish version are deeply complicated and could probably cover an entire lecture series on UK constitutional history, so let's not cover it here. What do these acts combined and separately provide? They create a right in law to access information held by public bodies in any recorded format, so digital, paper, microfiche, CDs, whatever. As long as it is recorded, which just means it's written down in some way, you have a right in law to access that information. And it's overseen by the Information Commissioner's Office and the Scottish Information Commissioner, who act as an enforcement mechanism to make sure that these laws are applied as they should be. Right, so now you may be thinking, hang on, aren't the UK railways privatised? What? This is information from the state. The UK railways are privatised. How does freedom of information apply to them? Well, you came here for a talk on trains, but secretly, no, this is a talk on mid to late 20th century British politics. So, UK railway privatisation explained not so briefly. Brace yourself, this gets messy. So, in the before times, there was British Rail. This was created as the British Transport Commission under the Transport Act of 1947. This was basically a result of the small disagreement of 1939 to 1945, which kind of broke the UK, and so something needed to be done. The then private railway operators, as a result of this, had no money left and could not possibly operate a service. A country without a rail service is not a very functioning country. See the United States of America. This was then corporatized as the British Railways Board under the Transport Act 1972. Corporatized is what many German people would call privatized. It's the same situation that the Deutsche Bahn is in. That is it is a corporate body owned by the government, but is still a public company. They kind of did everything because these railways had many business ventures and the government just scooped them all up into one big thing. And then the 1979 general election happened, and this is when Margaret Thatcher was elected to government. And she had some ideas, shall we put it that way, such as, wait, why is the government in the hotel business exactly? So this resulted in a large selling off of all the things the government had just willy-nilly bought up after basically the country went bankrupt. Excuse me. The railways themselves, though, were hard to know. Railways generally operated at a loss. This is one of the rules of public transport. They're not money-making. They are a public service. So you don't extract money from them. The government relies on votes from rural areas which are served by these railways. A fully privatized railway, if they just sold the whole lot off, would inevitably cut these routes. This is the same problem the Deutsche Bahn is running into at the moment with being forced to make a profit. They cannot operate some services profitably because there is no world in which that kind of service operates profitably. It is a service for the public good, not for profit. This would have been political suicide for the government, and Thatcher herself deemed it, and I quote, a privatization too far. I bet you that's not what you thought you'd be hearing about Margaret Thatcher. Meanwhile, in Sweden, circa 1988, previously, like in the UK, the Swedish State Railways operated both track and train. Around 1988, the Swedish State Railways were split in two. The Swedish National Rail Administration, I'm not going to try and pronounce the Swedish, owning both track and real estate, the SJ running the trains themselves, and rolling stock transferred to local regions, so councils, states, equivalent, etc. This appeared at first, keyword, to be successful. This resulted in the then European communities making a move with a council directive of the 29th of July 1991 on the development of the community's railways, which is an admirably brief directive for its consequences at a mere 4 pages. Important for us is Section 3, which required that there be separation between infrastructure management, i.e. stations, track, signalling, and the operations themselves, i.e. trains, passengers. So now the British government was forced to act to sell off these railways, and they had a fairly short deadline to do so. Or rather, they thought they were forced to act. There was no requirement to sell off the railways. It merely meant there had to be 2 government organisations talking to each other. The British government decided to sell it off anyway. This was enacted through the Railways Act 1993. So this was after Thatcher had left office. Now John Major was Prime Minister. This set up the privatisation of the UK's railways. And basically, instead of selling it all off as one British Rail Public Limited company, it was split into hundreds of parts. Railtrack owning the stations and tracks, subcontracting maintenance to 7 infrastructure maintenance units, 6 trackable new units, 25 train operating units operating passenger services, 6 freight operating companies, 5 of which got bought up by Deutsche Bahn in the end, 3 rolling stock leasing companies actually owning the passenger trains. This is a mess. Like, what? And predictably, this didn't go well. So Railtrack, being a profit-making company and not a company that was actually set up to look after the infrastructure they owned, would try to extract as much revenue as possible from the assets they had effectively been gifted by the government. This resulted in the Hatfield crash of the 17th of October 2000. A high-speed train derailed suddenly. This was a rolling contract fatigue-induced derailment, i.e. the track had been run over so many times without appropriate maintenance that the track itself disintegrated under the train. The faulty rail was known about prior to this derailment, and replacement rails were made available to the track maintenance unit, but they were never moved to the track for installation. No one was talking to each other. Everyone was just trying to get as much money out as possible. Some staff members were not even aware of maintenance procedures. Railtrack had divested all of its engineering knowledge, and notably, a zone quality standards manager testified, quote, "I do not have knowledge of railway engineering nor railway safety." Okay. So this resulted in Network Rail being created. Railtrack had no idea how many similar crashes could be caused by similar defects in the network. 1,800 emergency speed restrictions were put in place across the country. This basically ground the entire country to a halt because a country that is used to having a operating rail service suddenly not having a rail service generally doesn't go well. This was costing the UK economy about £6 million a day. These costs bankrupt Railtrack, and the government was forced to renationalise track and infrastructure under Network Rail. So less than 10 years after they started privatising the railways, it was already starting to fall apart. But the trains are still private, aren't they? Well, no. The train operating companies also have a habit of going bankrupt, and the government being forced to take over them because you can't just stop running a rail service. So between 2003 and 2006, South Eastern went bankrupt and was replaced by a government operator. Between 2009 and 2015, East Coast was also a government operator. And then from 2018 onwards, we've had a series of failures which have resulted in these being basically permanently put back into the public hand. London North Eastern, Northern, Transport for Wales, South Eastern, ScotRail, TransPennine Express, and the Caledonian Sleeper. One final addendum to all of this is the Rail Delivery Group, also previously known as the Association of Train Operating Companies. This group was set up as the railways were being privatised to coordinate the big picture between everyone. They handled industry-wide communications, marketing, ticket availability and acceptance, railway policy, and the national rail branding. I.e., because all of these railways were being split up into 100 different companies, there still needed to be some national brand for people to go, okay, well, this is the trains. Who do I ask about the trains? Because your average commuter is not going to understand that this service is operated by this company and this service is operated by this company. They just need a phone number to call when they want a ticket. And the Rail Delivery Group who are in charge of tickets, is still very much a private company. So we seem to be back to square one. Right, that's enough of that politics nonsense. You can stop having a nap now. So yes, tickets. Who in that mess controls ticketing and their specifications? As I said, it's the Rail Delivery Group, who are private, and so outside the Freedom of Information Act. That's great. Or, so you would think. The Rail Delivery Group itself may be out of scope of the Freedom of Information Act, but the standards they write are used by these public operators. And thus, they are in scope of the Freedom of Information Act, as in the standards, because they are used by the public operators, are in scope. More detail on why that is later. So, the plan. Find all the government-owned railway companies on what do they know. Ask for a copy of the ticketing specifications. Profit. So this is what I sent. This is a very big wall of text. I will attempt to summarize it. I am writing to request a copy of the following documents, blah, 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 blah. The RSP for both Aztec ticket types, so the tickets themselves and the discount cards. Any other specifications, public keys in some format, and any other public keys that they know about. Not so fast. The Freedom of Information and Freedom of Information Scotland Acts have some exceptions. For example, Section 21, information already reasonably accessible. So if this is already on a public database, you can't request it through FOI. Sections 30 and 31, investigations and prejudices to law enforcement. This will come in relevant later. Section 34, parliamentary privilege, as in you can't request a document from Parliament, or the government is in scope, Parliament itself is out of scope for, again, complicated constitutional British reasons. Sections 35 and 36 are government policy and prejudice to the effective conduct of public affairs, which is, how would I say, this is government euphemism for it would make us look embarrassing to publish this information. And Section 43, trade secrets and prejudice to commercial interests, i.e. We signed a non-disclosure agreement with a defense company and we don't want to talk about it. There's a few more, but these are the ones which are mostly relevant to us today. So, not to worry, we came armed with a list of reasons why these exceptions don't apply. If you'd like to read through the full reasons we gave, the requests themselves are public on what do they know. So, health and safety. Pretty simple. Ticketing is not part of health and safety of the railways. Very hard to dispute that. Personal information. British train tickets can contain personal information, but the standards themselves don't, so that doesn't apply. Trade secrets. This is another wordy one, but thankfully the British Information Commissioner's Office provided some useful guidance I could just quote at the rail companies, which is that disclosure should be liable to cause real or significant harm to the owner or be advantageous to any rival. Well, they use public-private key cryptography, so good luck. Also, the railways are effectively a government-regulated monopoly, so it's not like someone could just take these standards and set up their own railway company because they'd first need approval from the Office of Rail and Road to even operate such a service. Section 43, paragraph 2, prejudice to commercial interests. Again, the Information Commissioner provides some useful guidance we can quote directly back at the railways, which is, it is not sufficient for you to simply argue that because information is commercially sensitive, its disclosure would or would likely to prejudice commercial interest. You must be able to demonstrate a causal relationship between the disclosure of the information in question and the prejudice you envisage. And also, having a confidentiality clause in place does not guarantee that information will not be disclosed under the Freedom of Information Act. Basically, for the same reasons as discussed earlier, because the railways are effectively a government-regulated regional monopoly, there's no prejudice commercial interest here because the government would have to approve this prejudice in some ways. These requests have made a lot of people very angry and have been widely regarded as a bad move. So one of the people, one of the organisations I sent this request to was the Great British Railways Transition Team, who are in charge of basically the unprivatising of the railways now that we got a new government. Again, I don't have time to go into it, but they said, yeah, we don't hold these documents, but in the interest of transparency, I wanted to let you know that while we don't have these documents, we attended a call with experts from the rail delivery group who explained that placing the information you've asked for in the public domain would make it easier for criminals to print counterfeit tickets. This was said by a few organizations, so seemingly me sending these requests to different organizations triggered a bit of a crisis meeting between all the railway companies of, the fuck do we do with this request? Well done, Great British Railways transition team for making some slightly embarrassing information public there. So they relied on Section 31, Paragraph 1, Subparagraph A. Which is information is not exempt information by virtue of section information which is not exempt information by virtue of section 30, which is law enforcement investigations, is exempt information if the disclosure under this act would or would otherwise be likely to prejudice the prevention or detection of crime. So they're arguing that releasing these standards would cause ticket fraud. Would it? No. They use RSA cryptography. If you'd like an explanation of how RSA cryptography stops fraud from happening, see this paper. So I submitted appeals, basically saying, the fuck are you on about? This too has made a lot of people very angry and has also been widely regarded as a bad move. Northern Trains Limited replied, we disagree that the Act obliges us to engage in a speculative technical debate regarding RSA cryptography, or that it would be reasonable for us to take a 47-year-old academic paper into consideration when assessing our response.
The paper in question being the definition of RSA.
Yes, I thank their lawyers for such a wondrous statement on why lawyers shouldn't be let near computers. So, what do we do after we get such a rejected appeal? We appeal again to a higher power. The Information Commissioner. That too went well. The Commissioner's decision is that LNER, different company, but this was all one consolidated decision, is entitled to withhold the requested information under Section 31(1)(a) of the FOI. But they did say, okay, fine, we'll release a small bit of information, the bits that wouldn't harm the integrity of the railway companies. This is what I received. I have over 100 pages of this. They sent 3 documents, which had the title page and the table of contents unredacted, and the rest of the document was like this, for several hundred pages. It gets funnier, though. So, I quoted the UIC / European Union Agency for Railways standard saying, hey, this one's open, and this being open has not caused a huge amount of crime, so, like, explain the difference. And the Information Commissioner said, it confirmed that the Rail Delivery Group standards are not the same as the EU standards the complainant refers to, like the European Union Agency for Railways TAP TSIB 12. In their complaint to the Commissioner, the LNER advised that those EU standards are high level and do not include the UK-specific systems or the actual logic used in real devices.
For context there, those tickets in the UK, an Interrail is valid and issued under those standards.
Yes, the UK rail operators will accept an Interrail issued under TAP TSIB 12, so wonderful. Anyway, this document does actually include logic used in real devices. It has here, the header information, then you put it through SHA to get the thing, and then you do DSA, and then for verifying it, you do SHA and DSA again and check that the two things match. And if yes, okay, otherwise no, fraud. So yeah, it kind of does tell you exactly what you're doing when you're checking these tickets. There's a few more pages of this explaining exactly how different fields are used to check for different kinds of fraud. Oh, but it gets worse. They used my own work against me. So the LNER commented that there has already been a real-world case in Germany where fraudsters use publicly available e-ticket specifications similar to TAP TSIB 12, and a stolen signing key to create fake but valid tickets. It said the fraudster's barcode passed all checks because the information they needed to make an apparently valid but fraudulent ticket was public. I was the one who discovered this fraud. It's precisely because the ERA standard was available to everyone doing security research, or just anyone in general, that I was able to figure out what had gone on with this fraud, because the fraudsters had made a few careless mistakes in their tickets, and because I had access to the standard, I could tell what mistakes they'd made. If you'd like more information on this, there is a Heiser article that I co-wrote on it. It's also available in English if you click the British flag on the page. So, this is good. Briefly, Scotland. So, why is this information even in scope of the Freedom of Information Act? I said I'd get back to this. ScotRail, the Scottish national operator, thought this information wasn't. We responded on the 18th of December 2024 and formally notified you that we were refusing the request under Section 17 of the FOI SA. Section 17 is the "we don't hold this information" clause. We advise that ScotRail does not directly manage the issuance or specification of Aztec barcodes and digital tickets. Our online ticket booking engine and digital ticket fulfillment are handled by Trainline through a white label solution. Therefore, we do not hold the information requested. The Scottish Information Commissioner disagreed. Information is, quote, held by public authority for the purposes of the Freedom of Information Scotland Act if it is held in a recorded form at the time of the initial request for information. The information held by a third party on behalf of a public body may also be considered as being held for the purposes of freedom of information where the information belongs to the public authority. In this case, the information you have requested does not belong to ScotRail trains, therefore we neither hold the information directly nor is it held on our behalf. Except ScotRail is a member of the RDG, i.e. they own part of it, therefore it is information partly owned by ScotRail, so it should be in scope. So we asked the Scottish Information Commissioner. I've got a response a few months later. That's if 207/2025. If you want to go read the response, it's public. Basically, during the investigation, the authority reconsidered its position. So the authority didn't even have to come to a conclusion here. They just went, oh shit, this person actually knows how to appeal something, and then they thought about it a bit harder, and confirmed that it held the information requested for the purposes of the Freedom of Information Scotland Act. It said that the information requested was held by the Rail Delivery Group on behalf of its members, of which it was one. So, the ScotRail was then required to issue me a new decision notice, and under the condition that, yes, they did actually hold this information. So, small win. It's very likely that when this decision notice arrives by 16th of October this year, at the latest, what it will say is, well, we're still withholding it under the law enforcement exemption, but I still got a small win against them and proved them to be slightly incompetent. So, back to England. We need to show that the law enforcement exemption doesn't apply. After an appeal to the Information Commissioner, the next step is court. That sounds expensive, difficult. Don't I need a lawyer? No, it's free. Thankfully, the UK has a very reasonable tribunal system and is very accessible to individual people. I have filed all of these documents myself. Yes, you probably need to be slightly autistic to get it right, but who isn't? So this went to then Form GRC1, Appeal to the General Regulatory Chamber. And I filled this out, attached a PDF of my reasons for appeal, and sent it off. There are few more terrifying documents to receive in response to an email. This is confirming that there now is a court case between me and the Information Commissioner, the first tier tribunal of the General Regulatory Chamber. So what does the person who designed the system say? Of course, this being a court case, all the parties had to say who they'd like to call as witnesses if this goes to a hearing. The train companies named Ben Whittaker, the founder and chief evangelist, of Masabi, the company who actually designed this ticketing system in the first place. In a December 2008 blog post, he stated, even if hackers completely take apart a guard's scanner or a barcode, they will only be able to retrieve the freely available public key. They cannot make their own tickets unless they are also able to break 102.4-bit RSA at the same time. Now, let's ignore the fact that 102.4-bit RSA is probably not the smartest idea. I guess it made more sense in 2008, but this is a great look for your star witness in a court case. So, where do we stand? We've failed on FOI request, failed on the internal reviews, and failed on an appeal to the Information Commissioner, and now we have to sue them. The courts have said they will schedule a hearing either on paper or in person sometime around December, January, so you may well be hearing from me again with a further update on this. And now for something completely different. Slovenia.
Yeah, not to be confused with Slovakia. Both of our railways are shit, but one is shittier. So, first of all, for some context, because I'm guessing, unlike the UK, a lot of you don't know how public transport is operated in Slovenia. It is managed by the National Public Transport Management Company, fully owned by the government. They write the timetables, contract operators. They are also managing the central issue ticketing system that all operators must accept tickets from. Trains are fully operated by Slovenian Railways, which are fully owned by the government through another company in between, except cargo trains. They are 49% owned by a Czech company. Buses are operated by two major players. So Arriva, who at least is not DB anymore, which is fully private. Nomago, which Suja is currently in the process of fully buying them out to 100% ownership. So there will be a fully public company soon, TM. And APMS, which is a regional player owned by private equity and pension funds. There's two more operators for city buses, which are owned by the municipalities they operate in for Ljubljana and Maribor. All other city buses are operated by either Arriva or Nomago. Now, to provide more context, we need to talk about a specific company in Slovenia that does development of this called Margento. They are a Slovenian payment technology company that spun out of a previous company called Ultra, which collapsed due to political shenanigans. They pioneered mobile payments in early 2000s with Moneta and data over voice, which is a fancy way of saying we're doing frequency shift keying via the GSM codec, which, if things work, we should be able to hear it. This is what it sounds like when you, if you're a Slovenian student, you are redeeming your food voucher. That is advanced technology to their standards. They developed the Ljubljana city card back in the day. They have weird political connections because a third owner of the company is a former minister. They were recently bought out by Enghouse, which is a weird Canadian company that we don't know much about. But the main important thing is they developed the ticketing systems for basically the entirety of Slovenian public transport at this point, including Nomago, Slovenian Railways, EAPP, which is the system that is the new national ticketing system, Maribor city buses, and everything else. From what we can tell, it is all the same code underneath, which we also saw in mobile apps and the web management portals all having the same login screen. And an unattributed quote to one of their developers. We can just reuse the old project, right? Who cares about empty database tables? It's not like anyone would want to rent a bike through the national public transport system. Now, Slovenian freedom of information is a bit different than the UK, but it's mostly similar. So we have the Act on Access to Public Information, or we call it ZDIZ. We have a good stipulation in it that even companies performing services for the public that are contracted out by municipalities, the government, or anyone like that.
A similar but weaker clause exists in UK law.
And also anything that's like 50% or more owned by the state are subject to it. But only for the stuff they do as a public duty. And one example of an FOI request that we were able to do through this is requesting VINs and license plates of all the buses Arriva operates, which was another project that I'm working on. We have a public registry of all subjects that is actually kept nicely up to date by the Slovenian Companies House equivalent. And something that might be interesting for some people here that are working with trained data, since a few years ago, we added a special provision on dynamic data, which specifies that any data that is very dynamic needs to be made available through an API. That is fun. We're still currently establishing case law on this because even the Information Commissioner doesn't know how to apply the law that it wrote. So this is, for example, the registry entry for Slovenian Railways passenger transport. They have 3 legal bases to be an FOI subject. But I was here to talk about tickets, so let's talk about tickets. They try to follow some standards at least. So tickets are base64 encoded UIC tickets, as per the UIC standard that we've mentioned before. The old SSB variant of the standard, which the only other place we've seen was
Belgium.
Belgium, yes. But they're not quite fully up to the spec, as in they're not fixed length, which is what the specification stipulates. They are variable length in the part in between, and they're only using SSB as a header and container and signature thing. Unlike NS key cards, which after we got the specifications, turns out they basically copied SSB up to a bit.
NS keycards are also SSB. NS doesn't use SSB for anything else. They use the full barcode for everything other than a keycard.
Also, if you do want to get an SSB barcode, go to your nearest Deutsche Bahn station and get a...
yes, if you would like to see a funny SSB barcode, go to a physical Deutsche Bahn ticket machine and buy a...
disabled companion.
A disabled companion ticket for a cross-border ICE. This will charge you €0 and print out 2 tickets, 1 German and 1 Dutch with a barcode on it.
Those tickets are signed with a key that expired 3 years ago, but somehow the Dutch still accept it. They use proprietary types IDs as per the spec, except for number 20, which the spec technically says is UIC domain.
Yeah, they misunderstood a less than. No, they misunderstood a less than equal to be a less than.
Yes. But the standard is not published anywhere. So without resorting to FOI in the beginning, it is first a good question to ask yourself, how much can we actually reverse engineer, right? And that is when a Google Doc comes handy. This is a Google Doc where we have kept adding tickets for the past 3 years, just their payloads, and started noticing patterns. Like, all of them start with 001, 0101. And then, that's just a big end of the ticket number that's on my ticket. Also, stuff like, those look like dates. So after trying to engineer this, we discovered some stuff. We discovered that the date time is the same format that we have found in the EAPP standard, which was also a standard written by Margento for the government, then requested from Margento to make an app out of. What is conflict of interest? And it was published in a public standard, but the rest of the stuff did not really align with any of the public standards we could find. What was nice is all of the data that we were able to decode was using full bytes, so it made finding data in the big blob of data like something that would correlate a bit easier.
A lot of train tickets aren't byte aligned because you're working with a really constrained amount of data space and a barcode. So most standards use bit aligned data for ticketing. This
is also how the UIC invented, not invented, but used 6-bit ASCII, for example.
No, that was the British. The British used 6-bit ASCII.
And SSBs.
Yes.
So instead of start and end via stations, we noticed that each station pair we bought a ticket for had a different number in one field of the ticket. And that meant if we wanted to get a list of all of those, we would need to buy a train ticket between all different pairs of stations in Slovenia through all different paths. That would have been expensive. But we could reverse the rest of the enums with enough tickets, so we were able to get at least some of them. So in January of 2024, I submitted a Freedom of Information request. Yes, this is almost 2 years ago. I requested the barcode specifications and all the databases that are needed for decoding domestic and international tickets and the public keys used for both. First of all, what CCC did, because they did not want to deal with me after already failing at 3 different appeals in front of the Information Commissioner, was hand me off to DUIB, the National Public Transport Management Company, and said, oh yeah, they are managing our barcodes, which they are not. So DUIB at the time, in January of 2024, employed 2 people, the director and his secretary. They were just starting out and were established 2 months prior. They were clueless into what freedom of information even was, so much so that I got an email from the director of the National Public Transport Management Company going, I don't understand what you're trying to say. You're mentioning an appeal against who, why, who is rejecting what? We don't know what's going on. In the end, we did get them to kind of twist FOI because the law doesn't allow it, and hand the request back to Slovenian Railways, but that took 3 months. And I also, as soon as I got the handoff, appealed to CCC themselves and said, this is not about their system. This is not about EIOPA, but this is about your system. And I can tell that you paid for the system and you own the copyright for this system by giving them the public tender that they published. And then suddenly they were like, oh, you know what? Oh yeah, that is our system. So we got an initial response for some of the other bits, which was for international stuff. We were pointed at UIC standards, the UIC public key management website. We were pointed to merits, which is expensive. PKMW, we checked the big XML that the UIC provides, and we're unable to find the public key. But another thing that is stipulated in Slovenian law is having to pay for something means it's not available to the public, as the law says, which is an interesting thing that not all countries have. I was later appointed at the RailNet Europe Central Railway Database, which requires a RIX. Thankfully, I also have one, unlike this one, who is revoked.
Yes, the UIC seemed to have revoked mine since my Congress talk when I mentioned it, so, and aren't answering my emails.
We were giving the public key for international tickets after discovering it is not in the PKMW. We were also given assurance that we'll publish the key in February of 2024. That still hasn't happened. And then in May, right a month after I send the it is actually your system, they issued a decision denying access to us and denied all other points of anything related to domestic traffic. One of the specific exemptions they used was interference with the functioning or activities of the authority, which is, they said that I could create a virtual sales point, which to this day they have not defined what that even means. They said I could hack into their systems through a barcode, which, if that is true,
I mean, we've all heard of SQL injection, so barcode injection is right up there.
Yeah, of course, right? And the other one I got was personal information, because tickets contain personal information. Now, as Q already said, we were asking for the specification, not for the actual tickets themselves, first of all. And then also, at least according to their privacy policy, which, you know, is a legally binding document, they do not store that data in tickets. And the only personal data in the spec would be the author names, which they can redact. I don't care who wrote the spec. I mean, we already know who wrote the spec. It's probably the same people that wrote the EIOPA standard, but I digress. And now I just want to make a general list of, this is exhaustive, so this is all the different exemptions that apply in Slovenian freedom of information. Unlike the UK, we actually have it quite narrowed down. Classified information classified by the government. Makes sense. Trade secrets. There actually needs to be proof that they have commercial value, which again is easy to disprove in an FOI case. Personal data breaching GDPR. Makes sense. Breaching statistical secrecy. Basically, do not request source data from the National Statistics Office, which again makes sense. And then there's a lot of stuff that is obtained or compiled during current different types of court proceedings, which is just so you don't get an upper hand against the government when you're suing them. And then also, documents still being written that could be misunderstood, so basically draft versions of laws before they are sent in between departments. Also, protected information about cultural or natural values. For more context, this is basically, we have this really nice cave that we don't want people to know where it is. That's all that covers. And then the one that I mentioned, internal functioning of the authority, so being able to stop them from working and stuff like that. The main reason that exists is so you don't, for example, freedom of information, the schedule of police patrols for the next month. Which, okay, as much as we all know that, why would you not do that? And fun fact, in Slovenia, most police traffic stops are actually public on their website because they don't want people to speed. Usually that makes sense, but public authorities really love pulling that one out of the exemption bucket for, this will make our work harder. And then recently we added information defined as protected by the InfoSec authority. I still haven't seen a single document that's classified as protected. So we sent an appeal on the 5th of June, 2024. And then Slovenian Railways gave it to the Information Commission on 20th of June. At the end of August, I went to the Information Commissioner's website and looked at active cases. So you can see there that my case on the bottom that says requester Slovenian Railways passenger transport was submitted the 21st of July 2024. The next case still being handled is from April of this year. At that point, we realized that we might have broken the record for the longest running appeal case before it's going to court. So our arguments were, this is after the reasons, so just quick bullet points. They said that their system is not made for public use and not open source, which, okay, yes, and what? They said that there was a high potential for a lot of monetary damage without providing any backing claims.
Like in UK law, they have to provide a reasoning between how this would be used and how it would cause damage.
Yeah.
They did not do this.
We have still been asking ourselves to this day what a virtual sales point is. The public key has public in the name, which is a really funny argument to use. We also said that we're actually fighting ticket fraud with this. The argument that we made is, well, people could just, try selling a fake ticket on the Slovenian version of Kleinanzeigen when they don't use a return leg of, for example, an international ticket or a ticket. And the main reason that we're actually preventing fraud is, we allow them to actually scan the barcode and not have someone just print a random Aztec barcode on a piece of paper. We also said, UIC stuff is public, which, fair argument there. We said that they even gave us the public key for international tickets, so why they're hiding the public key for domestic use. Which, for context, SSB means that we can still decode the data, we just can't check the signature.
Unlike the UK, where you need the public key to read anything. Yeah.
And then we also went, public key cannot contain personal details, just in case we're trying to pull that one out of a hat. And again, printed tickets are not personalized, so even printed tickets themselves don't contain any personal data. All the personalized tickets are stored on actual RFID chip cards. The national equivalent standard, so the EAPP standard, is fully public. It just doesn't define paper barcodes in it. And also, another thing that they were trying to pull is there is copyright on the code that generates this. And I went through the contract in the public procurement. Guess what? You own the copyright, which they didn't know. So what then happened is what we call an in-camera review. The Information Commissioner going to the public authority and looking at the documents that you would receive if you were to win this case.
This will likely happen with the British court case at some point in the next few months, where the judge will be sent a copy of the documents in dispute and look at them privately to be able to make any judgments based on the comments I and the railway companies have said without anyone else seeing the documents.
The main important fact of an in-camera review is that it is only the correct thing to use when you're disputing the actual giving of information and the information in the documents being bad. It cannot be used, for example, If you're just disputing if, oh, this information, we all agree that this is public information, you just can't get an API, which is another case that we are fighting at the moment. So yeah, on the Information Commissioner sent us, just as a CC, we'll be visiting Slovenian Railways in a week and looking at the documents and giving them questions. And then on the 16th, we receive another letter from them saying, oh yeah, by the way, the thing got cancelled. Apparently people take holidays in July. But instead, the Information Commissioner opted to just send questions based on our appeals, mostly just direct quotes straight from my appeal, to Slovenian Railways. And also one of the other questions they asked was, okay, what documents are we actually talking about? Because you never specify that in the original decision notice, which is, again, breaching procedure. The first response from Slovenian Railways is that their ticketing system is actually a very big system. Oh, you don't say. And what does that have to do with anything? They say that it is key to functioning of the company, because if they can't sell tickets, then how are they going to run trains? I mean, you could always try being Luxembourg.
Yeah, it's free public transport. No one's ever complained about a free train.
They also finally specified what files we would get if we win the appeal, which is an Excel file for the spec, not even a PDF. Some CSVs and a PEM file. We use DSA, but even creating a barcode with an invalid signature is hacking into our systems, which again...
Lawyers don't understand how computers work.
Yes, and then they said that, this is a direct translated quote that I made sure I translated correctly. Our validators would let a fake ticket through if they don't have internet. Now, I understand that what they were probably trying to say is our validators don't locally store currently valid public keys, and if they are booted and don't have internet, we'll just accept any signature, which you have enough flash storage on the thing for one public key. It's not like you're using it for international tickets. They use their Android phones for that.
This bodes well for the quality of the rest of the code.
They also said that barcodes don't contain personal data, stepping back from the personal data exemption and going, but they can use the barcodes to link with payment methods and then depersonalize it. How would I get access to the financial system? They also said that, oh, but we are responsible for maintaining the public transport system that was commissioned to us by the government. Yes, sure, but I'm not asking about anything out of there. Oh, and then the funniest one, the source code contains patents, which, for anyone not knowing how patents work, you need to fully describe what you're doing in a patent. It only provides you commercial protection, not secrecy. They also had interesting opinions on the law itself. Specifically, they said that we would like to add that, in our opinion, the applicant's request exceeds the limits of legally protected rights under the Freedom of Information Act in a way that jeopardizes or interferes with our rights. Disclosure of the requested data would jeopardize the performance of the listed services or the provision of the mandatory public service we perform, or could lead to interference with our system in the manner described above, establishment of a parallel system, or as I was translating it earlier, virtual sales point. If the requested information were disclosed, we would be forced to take preventive measures and additionally at least change our operational processes or otherwise secure our entire information system. The threat would be too great.
So you mean to say that your system wasn't secure? Like, what do you mean?
For context, this is on record.
Like, this is public. In a public filing that anyone can pull on the internet.
And these are like, you know, affirmed statements that I can just go to a police officer or a judge and be like, they said this, they are incompetent, I want you to criminally charge someone. In this case, it is a matter of abuse of the right of access to public information. I don't think you're the ones to decide that. I don't think even the Information Commissioner is the one to decide it. I think that should go up to the Constitutional Court, right?
I don't know. Maybe. I'm not Slovenian.
And they said that we find it unacceptable and inadmissible that in order to comply with the legal requirements of the law, applicants would gain access to data and information that is essential for the very functioning of our system, and would thus be forced to jeopardize our own operations. In our opinion, this was not the intention of the legislator when adopting the law, nor is it the objective of the law itself.
I don't know. The law seems precisely on accessing data about internal systems, so...
Yeah. So we wrote a response to that. We said that, first of all, the data format is not connected to your systems at all. We don't even need any data from your systems, except, the list of all the station pairs and stuff. We said that the DSA is standard, and in FIPS, an old version, because DSA is not suggested anymore.
It's fantastically insecure, so...
Still runs European Railways.
They're working on it.
We're working on that, yeah. Which says public keys may be known to the public. And then we said, so what's the difference between an unsigned barcode and some gibberish data about selling fake tickets? Because, the person also won't be able to decode it. So I can just give them and say, oh, that's a valid ticket. Now give me money for my used ticket. And surely your offline terminals actually check signatures, and that was a typo.
Right.
Please.
Right.
Also, they can't presume I will commit crimes. More on that on the next slide. We also said that a public key has no copyright, because that was one of the things that they were saying. Which, if your public key is a work of art, I have questions about the randomness in it.
We welcome submissions of public keys or X509 certificates which are works of art. Maybe we can start a gallery.
We also said that the patent that they listed, which we went to check upon, is about NFC chip card tickets, not barcodes. So why are we even discussing that? And also, this is where we require the transparency into a system that at this point, multiple millions of taxpayer money has paid for, aka public money, public code, which is something that we are also having a separate case on, which is even older than this one, trying to get some source code from the Slovenian government and actually establishing some case law for public money, public code in Slovenia. That is, once went to court and back, and we're now waiting on the ICO to continue the process because the court didn't just fully decide on it. But yeah, as I said, difference from the UK, the prejudice to the prevention of crime is not really a thing that exists in Slovenia. So we do have exemption about interfering with internal operations, as I said earlier, but we don't have the specific stuff for crime. And yeah, a few years ago, I also made some more case law on that. I requested the vector files for the designs of the Slovenian Railways chip cards, which, autism, I want my SVGs.
They look pretty, they're shiny.
Yes, they claim that printing that on a blank PVC card would be fraud, even though the cards are this far and actually kind of secure. In the end, the Information Commissioner specifically mentioned in their decision what Q said earlier, which is, if we just allow anyone to say you will commit crime with the data you receive, public bodies could just use that as an exemption for giving you anything at all, and we do not want that. Which, thank you, Slovenian Information Commissioner, for actually understanding how freedom of information should work.
Slightly above the British Information Commissioner.
Yeah, their response again was, same BS as before, which I won't be repeating. They said that their public key is ADAS defined. As far as I know, ADAS is only talking about qualified trust service provider. If a railway is a qualified trust service provider, then I welcome them to submit that into evidence, but I couldn't see them on the EU trusted list.
Qualified trust service provider is, i.e. the Bundesdruckerei who issues the certificate on your EID, not the railway company.
Yes. Oh yeah, they also mentioned SHA-1 collisions would be easier with a public key.
I welcome I welcome a submission of academic papers explaining how that would be, because that's fascinating and I'd like to learn more.
And here's another fun fact. They use SHA-224, which is SHA-2. So yeah, at that point we said, we are requesting an oral hearing because we cannot do this by just sending letters up and down anymore. We are also welcoming the possibility of a court-approved subject matter expert. And that's when the Information Commissioner made a really interesting decision. They want to name a subject matter expert, which, good. The suggested one was sadly not a specialist of computer security, but computer science, but we were giving a way to appeal their suggested subject matter expert and replace them with someone else. The Information Commissioner also just out of their ass pulled the number of, we want €1,200 deposit for this. Because in Slovenia, even if I win the full appeal at the Information Commissioner, because of the way the law is written, I'm the one that started the process, and there is no parties with conflicting interests, because technically Slovenian Railways is not part of the process, even though the Information Commissioner keeps sending them the mail I send to the Information Commissioner. But even if we win, we are going to be the ones paying for that. So our response was, how about that other guy that's actually named as a computer security expert? We have one in the country, by the way. And I also disputed the made-up deposit amount. So after about a week of the Information Commissioner contacting the subject matter expert, they asked them for the price and explained the case, and the subject matter expert said, yeah, sure, I'll take that on. They themselves estimated the price of €1,000, and the Information Commissioner said that there would be no oral hearing at least until their work is done so they can actually gather facts, which, sure, that makes sense. And then in October, we actually paid a €1,000 deposit.
Fuck it, let's see what happens.
Yeah. So their work begins. The Information Commissioner issues a decision naming them, and in that decision, gives them a list of questions that the Information Commissioner made up.
Also, just for context, around this date, I hadn't even submitted my initial FOI request to the British Railways. That gives you context for how long this has been dragging on.
That is before Tsugli was started as a project.
Yes. No, slightly after.
That is before the Congress talk.
Yes.
So, at that point we realized we probably should have requested those before paying the deposit, mostly because the questions are, some of them are a bit, I wouldn't say stupid, just show how little the Information Commissioner knows about technology. One of the questions that I paid for being answered was, what is the difference between closed source and open source code?
Well, I'm glad we have a subject matter expert to be an expert on such a subject matter.
So, what happened then was the Information Commissioner gave the subject matter expert 2 months to produce a report. So, you know, Congress might have been fun if things ended up like they did, like we were expecting them to. Now, sadly, that's not what happened, and we're now in January of this year. At that point, I was attending a court hearing about a different FOI request that a friend submitted to the Slovenian Railways, because we always have at least 5 cases open. And at the hearing, of course, the Slovenian Railways FOI person was there in person. So I asked about, hey, about my case, have you done anything with the subject matter expert? I've not received anything for 4 months. And I get the answer of, oh yeah, we invited Duib back into the case, and we finally arranged a date in 2 months. And yes, at this point we're already 2 months past the original due date, and the viewing date is further 2 months. About the court case, by the way, it's a fun one. A friend of mine went to do their university mandatory practice, so a Tsubi kind of thing, at Slovenian Railways. Insert meme of flies into company, fixes issues bothering them, quits the company. Sadly, that did not go as planned. None of the issues that we had with Slovenian Railways were fixed in those 6 months. But we did now kind of have access to the Slovenian Railways intranet, or at least enough to poke and see, is there more data on the inside? We found that there was a JSON endpoint that would give us something that we wanted, which was what specific rolling stock was running on each train, because at that point we didn't know, when you were taking a train, you didn't know if you were taking the new Stadlers or the really old Fiats, which for some people matters because only the Stadlers have level access at platforms. They said no, it would be too expensive to change a line of config on our IIS server that's already exposed to the internet to allow an extra endpoint to be publicly accessible. And the ICO agreed to that. So we sued the ICO and won. And one of the things that happened in that courtroom was the judge asked my friend, what is your professional education? a Bachelor of Computer Science. Please note that down on record. And also, at the end of the hearing, the judge went off on the person from Slovenian Railways going, please don't tell me you actually don't know where your trains are. That was the judge, not me.
Just a bit of a safety issue there.
But yeah, we are still waiting on them to also appoint a subject matter expert in that case, and they still haven't decided on who it will be. We know it's not going to be the guy we suggested. More on that later. But yeah, the additional party, they invited Dui back into the case, and they said, oh, this data is actually related to EOPP and the EOPP standard. But we already have a letter from Dui from a year ago going, we don't have anything to do with this case, which I presented to the Information Commissioner. In the end, they allowed them to join the case, but they haven't really done much since joining the case. They're mostly there just to observe and maybe at some point poke stuff, but from talking to people that work there, they're there just because they kind of have to be legally and are not going to be interfering more. And then, finally, on the 28th of May of this year, I received the subject matter expert report.
Just a bit late.
About half a year. That day was the day of the passenger conference that DUIP organized, where we had most of the people working and organizing Slovenian public transport in one room.
Great time to organize a missile strike.
No, I was in there as well.
We'd warn you first.
Yes. So, just before the talks start, I get an email with the report from the Information Commissioner, sitting about 5 lines behind the person from Slovenian Railways that handled my FOI request. And the report is just 2 pages long for answering 14 questions. It doesn't specify any methodologies used. It is mostly going against us and confirming what Slovenian Railways was saying. And it just, in general, was a giant, kick in the nuts going, yeah, we basically figured out the subject matter expert just knows how to copy-paste stuff that Slovenian Railways writes. And from talking to more people which have handled with that subject matter expert, including some lawyers, apparently the guy also does that in court cases where they are, going after drug lords and stuff. The only thing he knows is how to read off of a paper. Sadly, I did not know that before requesting him. At that point, I realized that the report didn't even say, oh yeah, I read the files that were originally listed as being in the, as they would be given to me. So there was some attachments, some of them marked confidential, some of them not. Now, the funny thing is, one of the things marked confidential was the EOPP standard, which we already had a copy of because it's public and listed in all public procurements regarding the EOPP system. So what I did was I quickly submitted an informal FOI request for the exact version of the standard that they used in the report to the Ministry of Infrastructure. After talking to the person from the ministry at the conference, and they were like, oh yeah, we'll get it to you by the end of the week. Now, here's some highlights from the report. They printed the test ticket, which, cool, more samples. Which says test on it, is not printed and is not printed on CIT paper, but cool. And then they wanted to show, oh yeah, if you scan this ticket, you don't just get all the numbers printed out. So one of the employees, who Q and me know as Nelson,
yes,
lent their phone to the subject matter expert and used free Aztec scanner from the App Store to scan the Aztec code and showed this base64 blob. Then the subject matter expert was like, okay, but I don't trust this guy's phone. I'm going to do it on my phone as well. But his phone is an Android. So what does he do? Download QR code reader. What does he scan? Let me just make that clear for you.
The app doesn't know what an Aztec is and has somehow managed to create a UPC, i.e. a barcode you would find on a tin of tomatoes in Rewe from an Aztec.
Again, this is in the report of a subject matter expert who should at least know the difference between an Aztec and a UPC barcode.
Expert.
Yes. The aftermath of that. The ministry, of course, sends us a copy of the entire standard we requested, where there is still not even the barcode specification in it. For context, the barcode standard on the first page now says confidential because they made it specifically for the subject matter expert visiting. Also, we just received documents that were deemed to be confidential by someone who knows more about stuff than the FOI person at the ministry. That's going to be fun later in the court case. And so we write a very long response going point by point into everything that the subject matter expert has now written, and we go why it is wrong. Fun thing we did, because we wanted to stir some shit, we CC'd the Ministry of Justice, which maintains the list of court-approved subject matter experts. So the standard PDF we got had redacted the authors of the standard and therefore was turned into 560 pages of PNGs of text instead of text, because that's how Acrobat redaction works. So we used a government equivalent of WeTransfer that we have that sends you an email every time someone downloads and tells you which email downloaded it. Within 3 days, we saw that 10 downloads came from the link that was sent to Slovenian Railways, and more surprisingly, 20 from the Ministry of Justice. Looks like they might not like subject matter expert going to at least to this level of stupidity. Now, the sad thing is, we still haven't received anything official from them, but from secondary sources, I have learned that there is now an investigation into that person. So, that was where we also made another funny discovery. The domestic tickets are signed by the international public key.
You know, several years into this, someone goes, wait, hang on, have we tried this? And so turns out, no, we hadn't.
I write some Python and try validating the signature, and it says signature valid, and then I go, okay, let's make sure I didn't screw up that code, change some bits, and it's a signature invalid. At that point I go, oh, the fucking idiots. Because to this point, to this day, they have been claiming that giving me the public key that I now learned I already have would seriously impede operations of train ticket sales in Slovenia.
I note that they gave you the same public key under the auspices of, oh, this is the one we used to sign international tickets, this one is fine for you to have, but the public key we used to sign domestic tickets, not fine for you to have. They're the same fucking picture.
So, after that, we had this year's summer vacation. I had fun at Y. I think some other people had fun at other events. And then...
I was writing a paper. Academia stuff.
And then the Information Commissioner submits our response to the subject matter expert requesting explanations with the due date of the 8th of August of this year. The due date was, of course, not respected. Another reminder was sent on the 18th of August, where the subject matter expert at least replied by saying, I have too many other cases, it'll be done by the end of the week. It is currently September 12th. We still haven't gotten anywhere. So, where do we go from here? If we're looking into completely the legal sense, we could probably request another subject matter expert to disprove this one. That would probably be at least another 1,000 euros down the drain. If a decision is rendered without an oral hearing, which we have been requesting since then, and there is specifically something in the general law on administrative procedures saying any subject matter expert work should be presented at an oral hearing, we can sue the Information Commissioner for not knowing how to lead an administrative process, which is mostly how the lawsuits are done. You don't fight the stuff that was discovered, you fight how the Information Commissioner handled the case, and then the court can also make further decisions for that stuff. That's a €125 filing fee for the court, plus we need to write the actual lawsuit. We do get all the fees paid back if we win, so it'll be you get the filing fee back, and then if you file the actual lawsuit yourself, you get an extra €25 for the postage you used. If you get a lawyer, the lawyer gets fully reimbursed. So if you know a lawyer that's willing to work on the public tariff, and they see that this is a case you're going to win, usually they work pro bono because these cases are really easy to do, and they gave them some free money. But if we get proven right by the Information Commissioner, Slovenian Railways can also file an appeal to the court. And at this point, what we learned is public bodies sure love making up reasons to not give you data.
Yes, I mean this is why freedom of information laws exist, to force them to give us this data, but they love wriggling their way around it anyway.
And the other thing we learned is anything regarding technical standards or anything technical in general will be long and tedious, mostly because people who are working in these offices do not know a lot about technology.
Information commissioners and people who deal with public information in general aren't technical experts. We don't expect them to be technical experts, but they also are quite often fail to recognize the limitations in what they know about how things work. It may be nice for this increasingly digitized world we live in, that the Information Commissioner has more people appointed who can understand deep technical arguments about why something should or should not be in the public domain.
And not the way that I had it handled in Slovenia a few cases ago, where they just called in their in-house IT person who also didn't have any idea what they were talking about.
Yeah.
Because the only thing they know is how to deploy a new user in Active Directory.
Yeah, they manage Microsoft Office, not cryptography.
But yeah, the other thing is subject matter experts are expensive, but they can always be usually used as a last resort.
Yes.
If you're willing to pay for them, and that does make it a lot easier to deal with public bodies.
Yes.
But yeah, I think we finally reached the end of our talk.
Yes, so finally, the bit about Zugli that I promised way back at the start. In spite of all of this stonewalling by public bodies, we have got a lot of this information anyway through reverse engineering. So if you have train tickets and you would like to have a look at what's inside them, hopefully our reverse engineering is able to decode them. If they're Deutsche Bahn tickets, it definitely will, because we have the full standard.
We might be doing another talk at Congress, which will not be this freedom of information oriented, but very much public body oriented.
Yes. Here's our contact details, and I believe we have probably about 10-15 minutes for questions.
Yeah. Have we got anyone with a mic?
That's a very good... I guess you can shout and we'll repeat.
Yeah.
So, over there.
Oh, here are the mics.
Slightly off topic question, but I've wondered for a while.
Oh, how did the Zugli have the Deutsche Bahn font and the British government? So the UK government design system for their website is actually a really nice design system. It's open source on GitHub. Anyone can use it. I believe you can even make pull requests against it, and it'll get merged into government websites. And Deutsche Bahn also have their marketing portal where all the Deutsche Bahn style is available. So I just mashed these two together for the project.
Also, if anyone is looking to contribute to more open source, feel free to also send pull requests to the UIC barcode library. It severely needs them, as it's written in Java by someone who does not fully understand Java.
Yeah, the UIC barcode library is maintained by one guy at the Deutsche Bahn, and apparently us two making random pull requests. Right, yes.
In the context of tickets in the United Kingdom,
yes,
a lot of times railway companies will claim that accepting interrail tickets on their barcode scanners at the gates will enable fraud.
What?
Yes.
I've never heard this argument before.
I wonder, this is the answer I've gotten from the railway staff on multiple occasions. This is why I have to show them my pass whenever I want to go through a gate. Is this possibly something to look into too? Because they claim that UIC codes are fraud sensitive.
What I will say is, most of the times, the case is not that they don't want to support UIC barcodes due to fraud. It's more that would require someone to pay someone to implement UIC barcodes.
Yeah, because it's a completely different system, so they'd have to re-implement the whole barcode checking process for a different barcode format, and they don't want to do that. And then they claim, probably, I'm guessing here, that, oh, actually, it's because of fraud. I mean, there is no reason that a UIC barcode is more susceptible to fraud than a British Rail barcode. There are problems with both systems. They are both products of their time, i.e. early 21st century cryptography, and a lot more has been learnt about cryptography since then. But they are about as insecure as each other, and UIC barcodes are quite happily used in hundreds of thousands of euros of international rail travel every day.
And another thing I would add,
call their bullshit.
Yes.
I mean, another thing that you can always do is, keeping to the topic of the talk, freedom of information request, the reasoning for the decision to not accept UIC tickets. What I will say is from the reverse engineering that we've seen, one of the ticket control apps, instead of parsing the UIC fully, just has hard-coded byte offsets into where the pass ID and the passport number are in the pass, and then sends that to the EU-Rail ticket inspection website API. Instead
I
of...
think I'm filing an FOI request tonight.
Yes, have fun.
Oh, and they don't even check the signature.
Excuse me, what?
They don't check the signature because they are always expecting the train conductor to have an internet connection to be able to check the ticket on the EU-Rail API.
else on the microphone?
Next question. Are there more questions?
I don't see anyone.
Okay, cool. Well then, I won't keep you any longer. I believe there's a quiz or something happening here now, and I hope we haven't bored you too much. Thank you.